Hi, this is Emily Elison, just giving a brief CLE about a recent Court of Appeals case. I am currently at the Animal Law Section's meeting, so if anybody wants to join, this is the kind of stuff that we talk about. The case that I'm going to be addressing is State v. Newcomb. This is a case that came out in April of this year, 2014, that was addressing a search and seizure issue in an animal neglect case. So a little bit of background factually about this case is that the defendant was a younger woman named Amanda Newcomb. There had been a call in to the police investigators regarding her dog. A neighbor had expressed some concerns about the health of the dog and had made some statements about the care of the dog and didn't think that it was being well cared for. An investigator went and spoke with Miss Newcomb. She at first didn't want to talk to the investigator and then got in touch with him several times, and it took the investigator about a month before he returned to her home. She agreed to have the investigator come into her apartment in the apartment complex, and then the investigator, while he was in the apartment, through a glass sliding door, looked out into a backyard area, saw the dog, believed that it looked fairly emaciated and underfed. The owner of the dog, Miss Newcomb, made some statements to the investigator that she normally bought bulk dog food, but she was currently out of dog food and was intending to go and purchase some later that day to feed the dog. The officer decided that he wanted to confiscate the dog from her. She did not give him consent to do so, but the officer went ahead and seized the dog. He took it to a veterinarian at the Humane Society. That veterinarian put it on a feeding plan where it was being monitored with how much food it was given. It was being weighed on a nearly daily basis, and its weight was being charted every day. The veterinarian took a blood sample from the dog and also took a fecal sample from the dog and ran a litany of tests, and those tests revealed that there was no parasite or there was no illness in the dog that would have caused the dog to either have lost weight or not be able to gain weight or keep weight on. So that basically ruled out any reason for the dog to be what was deemed to be underweight other than the fact that it wasn't being properly fed. Ms. Newcomb then was charged with a single count of animal neglect in the second degree in Multnomah County. The dog, when it was taken by the officer, weighed about 45 pounds. That was deemed to be about 10 pounds underweight. And then by the time that it was at the Humane Society and it had been there for a period of time, it had gained about 8 pounds and weighed 53 pounds. The defense attorney in the case, which a caveat, was an attorney from my office, so perhaps I'm a little bit biased. The defense attorney filed a motion to suppress all of the evidence that came out of the blood tests, out of the fecal tests, and anything that came out of charting the dog's weight on a daily basis and keeping track of how much food it was being given and how much food it was consuming. The trial attorney presented a three-tiered argument to the trial judge. One was that there was a warrantless seizure without any valid consent and that there was no probable cause to seize the dog. The second was that there was no probable cause that the dog was evidence of a crime at all. What the officer saw through the sliding glass door didn't amount to probable cause. And the third point was that there was a warrantless search of Ms. Newcomb's personal property. So the defense attorney in this case was pushing the argument that animals can be property of their owners. The trial judge found that there was a plain view exception which allowed the officer to seize the dog and that what the officer saw amounted to probable cause of a crime, and found that no search had occurred whatsoever, either under the Oregon Constitution or the federal Constitution. So perhaps the takeaway from that for some folks in the animal law community is that there are some trial judges who are sort of willing to look at animals not quite in the complete 100% property view that some of the higher courts are looking at them as. So the case went up on appeal. Very similar arguments were raised on appeal in this case. The state put forth what the Court of Appeals posed as a really novel argument and basically said that the state had presented a novel claim that an animal's statutory rights trump a defendant's constitutional rights. And that might really be the big takeaway in this case, is that that's what the Court of Appeals rejected. The Court of Appeals found, in agreement with the trial court, that there had been a plain view exception in terms of a seizure, but then really highlighted the difference between the right to seize something and the ability to search it. So in this case, the Court of Appeals sort of affirmed earlier cases which have found that animals are property or can be property of the owners. One of the cases that the Court of Appeals cited was, I believe, State v. Nix, which is a case that had come out in 2012. I believe it's currently on appeal to the state Supreme Court. In that case, the Court of Appeals had found that each individual animal is a victim of an animal neglect crime if there's a conviction. The owner of the animal isn't the victim, but it's the individual animals that are the victims. And I think that that case probably gave some hope to certain people in the animal law community who would like to see animals not be a possession that someone can own or property, but instead sort of have their own individual rights. In fact, the Court of Appeals in Newcomb cited that case and said that even though these animals have statutory rights, perhaps as victims in animal neglect cases, that in fact they can still be the property of the owner, which is how they ruled in this case. So ultimately, the Court of Appeals came down in ruling that this had been a protected property interest of Miss Newcomb in the dog, and that when the officer, although albeit legally seized the dog, then when it took it to the veterinarian and the veterinarian did a blood draw and testing on the dog and the fecal tests, that's where the problem arose. The court found that that was a violation of Article 1, Section 9 of the Oregon Constitution, and that it was an illegal warrantless search. A couple of things to highlight here. One is that the state conceded an oral argument that the veterinarian was being a state actor. The vet wasn't solely acting as a care provider for the dog, but was acting at the request and at the direction of the investigator in this case, which made her a state actor. There wasn't any argument on that point, but there may be room for that in cases with some different facts. There really wasn't any argument that this dog didn't deserve to be cared for at all, but that ultimately, if the veterinarian wanted to run these tests and do the care, that was fine. They just couldn't be admitted as evidence against the defendant in this case, or that the state needed to go and get a warrant prior to these tests being run. The Court of Appeals also distinguished between the tests that were given. The Court of Appeals said that the drawing and testing of the blood was really the problem here. That was really what the Court of Appeals latched onto in reversing the trial court's ruling on the motion to suppress. There's a footnote in the case that notes that because there was no discussion either the trial level or the appellate level, and there was nothing in the trial court record to highlight how the fecal test had been done. Was it something that had been collected off the ground and then the test had been done, or was it something that was extracted from the dog? Because that would have made a difference to the Court of Appeals, it seemed like. The other thing that the court held was that the weighing of the dog and the tracking of the food that it was given itself was not an illegal search. That was because they found that the weight gain that the dog had was something that the veterinarian could have just seen, and that wasn't exposing any private information that wasn't otherwise available to the public. So the court drew some analogies with sort of the famous lifting up the boot on the front porch and looking at the tread of the boot, or touching the tire on a car to discover if it was warm or not, to see if the car had recently been driven. And so ultimately that's how the court divided between the blood draw and the testing of the blood and the weighing and measuring of the dog to see if it was gaining weight. And that's all I have on that.
I'd be happy to make comments.
Yeah, that might be a good idea. You're going to have to edit that in and out.
Can I come over here?
Please.